Kashmir, as we know, is the unfinished agenda of the partition. And despite several UN resolutions, starting from UN Resolution 39, 47, 51, 80, 91, 96, and so forth, India has always tried to wriggle out of these, and all attempts to find a solution to Kashmir dispute in accordance with international law and these UN Security Council binding resolutions has withered on the vines of Indian obduracy. We'll discuss today, Maham, what were the reasons of non-compliance by India, especially what happened after that watershed event of 2019, once India revoked Article 370 and wriggled out of the Kashmir's autonomy promises that were given to Sheikh Abdullah as a sop to his sensibilities. Pakistan, right from the start, was not very keen about any half-baked solutions.
Yes,
but it was PM Nehru's brainchild that Sheikh Abdullah should be fobbed off by a quasi-constitutional arrangement through a semblance of autonomy, flying his own flag, Sadr-e Riyasat, semblance of autonomy, constituent assembly. And later on, the same Sheikh Abdullah was incarcerated once he started asserting himself. And the Indian constitution was extended. Article 366 was also extended later. And slow nibbling of the autonomy provisions as enshrined in that Article 370 of the Indian Constitution, Indian Act, that was also done. And finally, in August 2019, Article 370 was revoked, followed by revocation of Article 35A,
yes,
the law for the permanent residentship. Now we see the whole journey. India used the first excuse that the conditions are not propitious, and the demilitarization requirements enshrined in those resolutions are not being met. Pakistan, on its part, always extended its cooperation, was ready to withdraw the troops, but Indians insisted always that there should be complete withdrawal of Pakistani regular troops, wherein India should be allowed to retain certain level of troops, though that level was never specified, and the Indian intentions were also not very noble. So much so that Owen Dixon, charged with this responsibility to find a solution or any acceptable solution to this dispute, he also acknowledged in Owen Dixon report that had Pakistan allowed India to abide exactly by the provisions as India wanted, then Pakistan later on would have experienced certain things that would not have jibed well with their understanding of the electoral realities. In simple words, Pakistan would have accused India of rigging. Well, this was what was prognosticated by an independent UN official, Owen Dixon. He went as far as to propose a partial plebiscite solution with areas that are Hindu majority remaining within the Indian administrative control, the Muslim majority districts with Pakistan, and plebiscite in the Srinagar Valley extending till Muzaffarabad. Despite all those workable options and various variations, Nehru and Indian leadership always repudiated these well-meaning suggestions. And this issue kept hanging fire, leading to 1965 war, followed by 71 war, and then the Shimla Agreement, in which India now claims that no mediation is possible because the Shimla Treaty clearly says that issues would be discussed bilaterally. But Indians are not reading Article 4, Subpara 2, which also says in the same treaty that the line of control, which came into being as a consequence of Shimla Agreement, starting from December 17, 1971, as the situation was, that line should be respected by both the countries without prejudice to the recognized position of each country. So, Pakistan's recognized position is very clear. It's rooted in UN Security Council resolutions, which are still alive on the agenda, and that is Pakistan's consistent stance. And the revocation of Article 370, then introduction of reorg, Jammu and Kashmir reorg order 2020, and after that it's revocation of 35A and doing away with the permanent residency status. It partitioned the state of Jammu and Kashmir into two federal union territories.
Yes, sir.
And the situation now that obtains in the valley and the rest of the Jammu and Ladakh is that the whole erstwhile state, which we now refer to illegally occupied Jammu and Kashmir, is seething with discontent.
Yes, sir.
Issue and discontent is simmering, which keeps erupting sometimes in the form of Burhan Wani's, in 2016, that was a spontaneous uprising. There was a spontaneous uprising in 89. And it is in the same tradition that this Pahalgam incident happened. Nobody knows who did it, and not a shred of evidence against Pakistan. But squarely the blame was placed on India, finding a scapegoat and presenting a false image and a Potemkin reality of everything is honky-dory in the valley, whereas everything is not right.
Yes, sir.
People are disaffected. Constituencies which are being altered have elicited a lot of antipathy by the political parties across the party line. Every political party has opposed those Indian attempts to impose its demographic solution on the Kashmir. The property is being snatched. The constituencies are being gerrymandered to ensure that in future a Muslim majority state becomes a Hindu majority state, and a BJP government comes and they further validate. So as an international law expert, I would like to pick your brains on revocation of Article 370. This was an article of Indian Constitution which had given the protection to the state of Jammu and Kashmir's leadership that only Constituent Assembly which could revoke it. But that Constituent Assembly had dissolved itself in 1957, and then it was stated probably by the Indian courts also that this article has attained finality because there's no way of revoking it. Because the Constituent Assembly that was supposed to be consulted before its revocation stands dissolved.
Yes,
so how did India, how does Indian stance square with domestic law or international law on that score?
So, thank you, sir, for the question. So, sir, the Indian stance on the revocation of Article 370 is completely incorrect. And this is not just my understanding as a young international lawyer. This is the understanding of established practitioners of international law as well. So, first and foremost, if you look at international law, there are regions where the territories and the boundaries are clearly established and recognized, as was the case with Pakistan and India at the time of partition. So the international law pertaining to them and the right to self-determination pertaining to them is very different with regards to the right to self-determination of a territory whose boundaries have yet not been defined. And the threshold of to the extent to which that right can be exercised is henceforth that way. Uh, when we talk about Article 370, sir, I completely agree that once the Constituent Assembly failed to exist, the article had attained finality. And that is the argument that the Indian citizens who were against the revocation themselves is what they took before the Indian Supreme Court. So this is not just our understanding of it. This is the understanding of a significant portion of also Indian academics who do not want to live and see a country do something that is completely rogue, as we call it in international law. Sir, there are two aspects to the international law Kashmir issue. One is the status of Kashmir, which India, apart from its domestic law, because of the existence of UN resolutions. And sir, mind you, the case which was taken to the Security Council by India itself. So unlike other situations where India says that its sovereignty was violated because it was forced to go somewhere, that was not the case. India took it to the Security Council. The resolutions were a result of India tabling it before the Council. And then to turn around and say that we don't agree with the resolutions is completely not the way you operate in a multilateral setting. So that is the territorial issue, because the Security Council has given its the resolutions on it. And they're very clear, sir. Two aspects of the resolutions can absolutely not be contested: the demilitarization of Kashmir and the plebiscite. So now what India has till date dragged its feet on is the fact that they said they have read the resolutions in a way that suits them, and they've said no, the plebiscite is dependent on the demilitarization. So the demilitarization will come first and then the plebiscite. So that is absolutely incorrect. There is no Security Council resolution that says, yes, the Security Council's resolutions do say that demilitarization is important, but they've placed equal importance on the weight of a fair and free plebiscite. That is the exact phrase that's being used. So India till date has incorrectly interpreted the Security Council resolutions.
Yes, I'll sorry for interjecting, but there's a UN Resolution 96, which very clearly enunciated that Pakistan and India have established a mechanism to put into place a plan for demilitarization, and the UN representative, he expressed satisfaction. So that resolution 96 is very, very clear. Yes, that situation is ready, situation is ripe, and it only depends upon how that plan of demilitarization is put into effect.
The logistics of it.
The mere fact that India has not agreed to it and has always dragged its feet has resulted in its scuttling.
Sir, I completely agree. And just a bit off topic, but sir, this has been the Indian position on international law overall. They've done the same on Indus. When the impasse was reached in 2016 over the neutral expert in the Court of Arbitration, so many options were tabled by India and Pakistan and the World Bank. India dragged its feet. It said that none of them are acceptable. So, sir, and I'm going to echo what Ahmed Bilal Sufi, another international lawyer based in Pakistan, says, that this is India's approach towards international law. But so why is it so problematic? It's problematic because when it comes to Kashmir, like Palestine, is a recognized territory whose boundaries are yet to be established. And so what India has now started saying is that they have started labeling the Kashmiri people's fight to self-determination as terrorism. So that is absolutely incorrect. I'm not saying that you can do whatever you want with regards to self-determination, but sir, there is a very strong consensus in international law that when a boundary is yet to be established, the population of that place has the right to with using proportionate force, resist illegal occupation, and that's exactly what's been happening. So to label people incorrectly is also blurring the international legal arena with regards to how you deal with it. Why that is important, sir? Because then they've taken the conversation away from the territorial issue of Kashmir into the fact of what those people are doing to occupy that. That's number one. And number two, the second international law issue is, sir, the massive human rights violations in Kashmir. And it's not something that just Pakistan is saying. There have been independent international organizations, Amnesty International and all, who have, by the way, now stopped. They've been prohibited from operating within India precisely for this reason, because they started shedding light on the massive human rights violations in Kashmir. So India, in addition to the UN resolutions, is also party to multiple treaty-based human rights bodies, such as the International Convention on Elimination Against Women, Protection of the Child, Protection of Social and Economic Rights, International Convention on Civil and Political Rights. All of those are being violated, and there's no accountability for that.
And there are draconian laws like Public Safety Act, UAPA, and Terrorist Disruption Active, TADA laws, POTA laws. So
Yes, sir.
all those laws are so draconian that those snatch away the privileges and don't give any rights to the
Kashmir.
residents of Kashmir.
And sir, the most important part is they do that, and in light of the fact that India itself voluntarily has signed all human rights treaties. Either you don't sign them. If you've signed them, you've taken on the obligation. Sir, there is like a significant body of international scholars who say that even if you're not physically killing people, but what India has done with the citizenship, they've diluted the ethnic identity that is akin to ethnic cleansing. Because what you're saying is you disperse their ethnicity to such an extent, and with forced intermarriages also being an issue, that you're eventually, the idea is to wipe them out, right? So,
and some go as far as claiming that what is happening there is war crimes, because if Indian security forces are there in violation of international law, then they are occupation forces. And if those are occupation forces, then they are committing war crimes. And war crimes are specific, what
yes,
they
sir.
are doing.
Yes, sir.
But then there is a widespread and systematic killing, rapes, tortures, use of pellet guns, incarcerations.
Sir, yes.
According to a
The
letter.
use of white phosphorus, sir, which
Yeah.
is completely prohibited under
Yeah.
international law. So, white phosphorus can only be used during wartime to eliminate buildings.
So other than war crimes,
Yeah.
it comes in the category of crimes against humanity.
And sir, genocide. So, sir, the word, a very good word that you've used is the systematic. So, sir, the genocide convention says that anytime the intent is to systematically target a particular population, that is something that constitutes genocide. And because the systematic targeting of Indians, and sir, you could kill them, but again, as I said before, forced marriages, you're diluting their ethnic identity by intermarrying Kashmiri women, and you've killed off the men. So how and if you but it's important to say you've limited their right to procreate their own and to further their own generations, and again, and that coupled with the citizenship situation, the property ownership situation, you've taken away their property. So property in international law is recognized as an identity of culture and ethnicity. So, and property rights in international law are very strongly protected. So, even to the extent that a state itself cannot take away cultural and heritage property from people, from the indigenous properties. And so, we've seen this in the United States, we've seen this in Canada and a number of Western states, that indigenous property land holdings are protected. You cannot, if you need to, even if you, so I've seen this in a couple of countries, even if you need to make a university on them, you need express permission from the indigenous community to do that, because it's such a strong human right that needs to be protected.
Jammu and Kashmir Reorganization Order 2020, adaptation to state laws,
Yes,
and
sir.
removal of difficulties clause, that has done away with that permanent resident status
Yes, sir.
and allowed the domiciles to be given to over 2.5 million non-Kashmiris, which would alter the demographics
Graphic, yep.
of a state where there is already so much deprivation, so much poverty. If their identity is also being snatched, their jobs are also being snatched, their property
Their
is
homes
being
are
allowed to be
yes, sir.
purchased, and the whole community is in danger of losing its identity, and that elicits
And so eventually
resistance.
withering away, because they're going to wither away, right? And the idea is that international law, particularly with regards to human rights, so you're aware of this as well, that even if it's a conflict zone, right? So what India is saying, that because we're fighting this war against terrorism, which they've come up with from God knows where, so it's a conflict zone. But sir, then the Geneva Conventions apply. So they're so particular about, number one, there cannot be any systematic targeting of civilians, which we've seen in the situation. So there cannot be any enforced disappearances during that, which, so we have multiple accounts of Kashmiri people who people have no idea where their husbands and brothers and sons are, and some people have now resigned to the fact that they're never going to see them again. So because the court system is also under the Indian Supreme Court now, so the idea is, where do you, one of the main identities of a state is the rule of law and the access to justice it gives its citizens. Kashmiri people have no access to justice, so where will they say and file a habeas corpus petition for a missing person?
You see, a tyranny of majoritarianism is being imposed upon a hapless populace, which is at the mercy of the Indian constitutional hegemony. You see, once you rob them of their right of democratic and free means of expressing their will as enshrined in the UN resolutions,
Yes, sir.
you rob them of their property, you rob them of their right to the jobs in their own state, and you do not allow any UN military observer group to observe, and you don't allow any independent journalists. So there's a complete iron curtain imposed, and the world is not taking any notice.
Sir, on this very important issue is another violation of India that is now also being has been taken to the International Court of Justice by the General Assembly for an advisory opinion, is whether so the General Assembly has said that a state who is party to the UN cannot stop the UN and affiliated organizations from providing humanitarian aid and assistance to a population or a country in need. So we've seen this happen in Palestine, right? So Israel stopped even UN observers from coming in. It stopped humanitarian aid, and that issue was tabled at the at the General Assembly, and they were like, okay, we now need to understand, can you stop, if you've become part of the UN, can you stop the UN from operating? And the General Assembly didn't outright say, no, it's a state sovereignty, you can do it. The General Assembly said, no, this is important, and we can't, this is a possible question for the ICJ. There is, to a certain extent, a country cannot stop the UN from operating. So they've actually referred that question to the ICJ, and it's pending. The hearings have started, and they're deliberating on the rights and obligations of a state vis-a-vis the United Nations as well.
Yeah, ma'am, we know that
Yeah.
all attempts at diplomatic solutions have foundered on the rocks of Indian hubris. But why international law options have not been able to force India into a state of inconvenience at least? We know that there are draconian laws which I just enumerated: TADA, POTA, UAPA, Public Safety Act, and each one of those violates one or the other sub-articles of International Covenant of Civil and Political
Rights, yes, sir.
Why is it that we haven't been able to move the case to, or present our case at UN Human Rights Council to at least constitute a fact-finding commission, UN mandated, to go to state of Jammu and Kashmir and give a detailed appraisal of these human rights
Situation on ground. Yes, sir. So, sir, when we talk about international law options, we always have to understand that international law cannot operate in isolation from international relations. So even if we go to the Human Rights Council right now, and India stops the Human Rights Council's investigators from going to Kashmir, uh, how are they going to come up with a fair and unbiased
so there the weakness of international law comes.
It is,
unfortunately.
sir, the weakness of international law has become so blatant with regards to the Palestine issue as well. But sir, one thing that I do think is important is to still keep on hitting at a wall and something, and to keep on at least putting this case on the docket of the Security Council, of the General Assembly, of using whatever tool arsenal you have in your back pocket. And so it's not just the Human Rights Council, it's also so many other treaty mandated mechanisms that could become available, provided that enough work is done to, and we can see that who sits on the committees and what's the most favorable way to go about that. For instance, the Committee on the Elimination of Racial Discrimination is very robust, very active. We've seen countries who otherwise did not have a legal option tabling their issues there. And there are committees on the protection of children, because the Kashmiri children would really need protection. There are committees on the protection of women. There are committees on the protection of migrants. So there are a number of treaty-based committees that could possibly are soft law options, but could possibly be a very good diplomatic / legal lawfare tool to use. But at the same time, I am the first one to admit that international law has its shortcomings.
We know that the likes of Ratko Mladic, they were brought in the dock for their war crimes. And why isn't that somebody from Indian occupation forces has not been put in the dock by invoking universal jurisdiction? That's something very interesting that I believe you can elaborate upon.
Sir, and this conversation has happened before of using universal jurisdiction, which is basically where you can take an individual to any court of any domestic court if that domestic country has a universal jurisdiction statute. So it's very expensive to do that. Kashmiris do not have that kind of money. So I've actually spoken to a Kashmiri and they said we've tried to find a case. So another shortcoming of international law is you're not going to find pro bono lawyers who bill insane amounts of money per hour taking up these cases. And sir, you look at it logistically, for a Kashmiri to say, so Argentina has a very robust universal jurisdiction law. For them to take a case to court is an expensive endeavor. So money has always been one of the defining factors in that. And another thing is, sir, the organization. You've also, most of them, their education is also lacking. The idea is that you need enough people need to be invested in this issue from amongst the Kashmiri people as well, and be so aware of the international options that they have, because in addition to other countries doing it, there are a couple of options that the Kashmiris themselves can also take up. So, universal jurisdiction being one, there are Magnitsky style human rights sanctions that the UK has, which are basically sanctions on individuals and organizations that further human rights in any part of the world. But as I said, so all of these are very complex, and for a layman to approach them is going to be hard. And secondly, they're also expensive options. You need to put money into it, sir.
There were times once India and Pakistan mulled over the options of thinking outside the box and find an interim solution pending the final settlement.
Yes, the Musharraf
Manmohan Musharraf formula.
Yes, sir.
And before that, UN representative, Owen Dixon gave, Frank Graham gave this idea of regional plebiscite. partial autonomy. Manmohan Musharraf formula essentially was about retaining control by each country of Muslim and Hindu majority areas,
yes, sir.
with the
Free movement of
free movement,
goods and services and people. Yeah.
and a kind of soft borders,
Yes, sir.
visa-free regimes, and
And
retaining control
yes, sir.
on defense, currency, and
And sir, joint
communications,
administration.
joint administration.
Yes, sir.
And waiting for 7 years, or maybe waiting for another 7 years, taking it to 15 years,
Yes, sir.
to then re-evaluate and review
Yes,
if
sir.
the situation warrants another solution before going for the final settlement based upon the UN resolutions. So all those initiatives also were rejected by India,
Yes, sir.
essentially.
Yes, sir.
And then I come to the mediation part,
Yes,
because public memory is short, but this standoff in May between India and Pakistan, which was essentially because of Kashmir,
Yes, sir.
and India accused Pakistan falsely of involvement in Pahalgam without a shred of evidence,
And yes, sir.
and then launched attacks in violation of
Yes.
international law.
Yes, sir.
I'll ask you to comment on that also. But this violation of the essential abnegation of negation of these UN resolutions, now India has completely thrown away that even pretense of
Bilkul, sir.
treating Kashmir as a dispute, and we still are toying with the notion of international mediation. Pakistan has always welcomed. In the past, two incidents are noteworthy. Once, I think it was by Kashmir American Council. There was an initiative. They offered mediation. Pakistan accepted. Kashmiris were also receptive, interestingly, but India rejected. There was a Robert Wursing mediation effort also. That also was accepted by Pakistan, accepted by Kashmiris, but rejected by India. This is something very strange. Now President Trump, he has offered mediation.
Yes, sir.
And Pakistan has accepted. India has flatly rejected it.
Yes, sir.
They haven't even recognized the facts that President Trump has played a very important part in brokering this ceasefire, which unless done would have led to a cataclysmic nuclear holocaust between two nuclear armed nations. So how would you see those attempts at mediation, and is there any scope in international law of mediation on an issue which is already on the agenda of UN Security Council?
So, sir, with regards to mediation, definitely. Sir, the first thing that you said was that India has come, what we need to first make India realize, or at least start doing ourselves, is keep on hammering the fact that this is not a domestic issue of India. They started with the fact that it was an international issue. Then they said, no, it's a bilateral issue, so no one else needs to intervene, because their intention was always to strong arm and be a bully and do whatever they deem is fit. And now, sir, they've completely relegated to a domestic issue. The foremost evidence of that being that when their Supreme Court came out with the judgment that affirmed the decision to abrogate Article 370, the entire judgment of the Supreme Court of India, which is very comprehensive, so it's almost 300 pages, if not more, they have not once mentioned the word international law or Pakistan or UN Security Council resolution or UN or resolution. That means they have completely taken it out of the international domain. They have said our constitution, Kashmir is ours. What we did through our constitution is completely our internal matter. So, sir, that is something that needs to be first and foremost flagged at every situation, that just because a country from within itself has decided to do something, that is not how international law works. You cannot do that. So, secondly, mediation. So, mediation has always been an option. So, unlike Unlike India's stance that post the Shimla agreement, no.
Americans did it for Israelis and Palestinians.
Yes,
Oslo
sir.
Accord and
Other things as well.
those
And so
bore
even
fruit.
informal mediation, we've seen Qatar do it a couple of times, even if you're not formally involved. So we've taken mediation when we wanted to sign the Indus Waters Treaty. The World Bank was very heavily involved to the extent that it became a signatory to the treaty. So it's not like India takes up mediation when it suits them. So with Pakistan, sir, what I think India's position is now that India has completely gone rogue. And that is what international law calls it. They have held the treaty, Indus Waters Treaty in abeyance, also clubbing it with the Pahalgam incident and terrorism, which absolutely makes no sense, sir, because those are completely two distinct things. It is completely, and because the water treaty stands valid, India has gone in perpetual abeyance of the treaty. It is doing the same thing in Kashmir. Short of being calling India a bully, and under international law, there is no way that India can justify its actions under international law. And mediation is very much an option, sir. So international organizations were created with the intention of ensuring that there won't be situations where conflicts will erupt beyond a certain point. And so it's not, you could go to the UN. If you have a human rights issue, you can go to the Human Rights Committee. If you really want to resolve a dispute, boundary disputes have been resolved by the ICJ. You can voluntarily accept the jurisdiction of the court. There's a panel of excellent international lawyers who dealt with boundary disputes multiple times. So, sir, the way to go to a mediation or arbitration or whatever, there's a permanent court of arbitration if you want to go to arbitration. So all of the options are there. It's the intent of wanting to fix a situation and move forward in good faith. And so we this is a term of contract law as well, and overall international law, that states are expected to operate in good faith, not with underlying motives and just doing something on the face of it. So mediation options are very much there if they want to be exercised.
And lastly, Maham, we have heard this term genocide.
Yes, sir.
In the Palestinian context, and how South Africa has taken
Yes, sir.
Israel to ICJ and what direction ICJ has given. We also heard this term in the context of Kashmir.
Yes, sir.
The head of this genocide watch.
Yes, sir.
He alluded to eighth stage of genocide. There are total 10 stages.
Yes, sir.
Last is the extermination. I know it's the trouble with taking somebody to international fora on violation of genocide convention and accusing a state entity of genocide and proving it is difficult because of the intent factor.
Yes, sir.
How do you read this in the Kashmir context?
So, sir, with the Genocide Convention in itself, the Genocide Convention in the past 5 years is the only convention that's seen the maximum amounts of cases being filed before the ICJ, which shows the lack of tolerance by the international community for anything that could even broadly constitute genocide. So, sir, you spoke about the South Africa versus Israel case. There's the Gambia versus Myanmar case. Then even a case was filed, although never went to adjudication, that was between Russia and Ukraine. All three cases were filed on the basis of the Genocide Convention, taking that as a jurisdictional basis. So, sir, but the point of saying that is to show that the international community has zero tolerance for it anymore. They're like, one thing that is absolutely unacceptable is any form of genocide. So the intent requirement of genocide is actually very simple to understand. It's the fact that any one country intends to completely eliminate one racial or ethnic identity. And that intent can be judged from a number of factors. You could exterminate them, or you could completely wipe them out. You could slowly try to strip away their identity so they're no longer what they used to be. You can prohibit them from having kids.
So this demographic change that India is trying to effect,
yes, sir,
by changing the property rights, by giving domiciles to non-subject Kashmiris, by forcing depopulation,
yes, sir,
by changing the constituencies, and using fertile jungle forest land for industrial projects.
yes, sir,
This also comes under this relevant provision of genocide, because this amounts to robbing an entire community of its identity.
So it definitely could, because, and it does, sir, because the idea is that what we can see from all these, so intention always has to be inferred. Unless someone comes on live TV and says we want to commit genocide, intention in law, not just international law, it's always inferred. And so all of these steps are show that there is an intent to ethnically to wipe out an ethnic or racial community. And so that, again, I want to reiterate, that doesn't necessarily mean that you have to exterminate them. You could do it by other means, and that's exactly what India is doing, right? So and the idea is, do we want to live in a world where we wait for the genocide to happen and then stop it? Or do we want to now be more proactive, having this world seen a Rwanda? You've seen other instances of genocide happening, and the impact, the debilitating impact that it does have, to actually step up while it is happening and say, like South Africa has said, that you need to stop before you completely eradicate them. But sir, definitely, genocide does not necessarily have to, the killing is the last stage. You can completely stop, you can start eradicating them at different levels. You can take away their jobs, sir, they will have no livelihood. And you can take away healthcare, from what we've seen in Kashmir, right? People are going to die. Infant mortality in Kashmir is so high because their children are not born in proper hospitals and are not given the care. So genocide can take many forms, but the intent can be inferred from all of these actions.
The worst rebuff to international law is to completely ignore it. And unfortunately, by revoking Article 370 and illegally integrating a disputed area with the with India, a gross sin, I must say, has been committed against the norms of morality, and international law obviously is in complete breach. So with this, Maham, thank you very much.
Thank you,
and
sir.
from IPRI, stay tuned. We'll come back to you in the next update on Kashmir and international law. Thank you very much.
Thank you.